Welcome to Close to Home with Nicole Sullivan.
Welcome to Close to Home with Nicole Sullivan. I'm your host, John Clements. Nicole, a lifelong Mississippi Gulf Coast resident and experienced attorney, shares her legal insights on everything from real estate to estate planning, bringing clarity to a complex field. Today's episode is Closing the Deal, Legal Essentials Every Homebuyer Should Know. But before we dig into that, Nicole, just want to say welcome back to the show. Glad to see you.
Thanks. It's good to see you.
Let's jump into something that everyone who is going to buy a home or has bought a home really needs to know about, and that's closing the deal. So let's just jump into some questions. What's the difference between a quitclaim deed and a warranty deed, and when should each of those be issued?
So the funny thing to me is when people call it a quick claim deed with a CK instead of a T, it's a quit claim deed. Which I believe you pronounced it correctly, but it is funny to hear the mispronunciation of this type of deed. But a quitclaim deed is one that doesn't have any warranties. So when the person that is taking title to the property, the person that is receiving the property, being given the property, they are not given any warranties. So they're taking on a lot of risk. And an example of that would be, let's say someone purchased the property for taxes at a tax sale, and they are going to transfer their interest over to another buyer. Most of the time, they only own the tax interest at that point. They don't have what's called fee simple interest, which is 100% ownership in the property, and whomever is receiving that property takes on the risk. Most of the time I see quitclaim deeds in situations of family property. So let's say mom and dad own a home and they want to give the home to the son or daughter, or whomever it is. Then many times a quitclaim deed is used. And the reason for that is title has not been searched. So we don't go back and look through who all's own the property, if there are any encumbrances, if there are any judgments, whatever they may be. Whomever is being given that property is taking the property subject to any problems that may exist with that property. If you're talking about a warranty deed, for example, these are typically the type deeds that you are going to receive at the closing table when you are doing what's called an arm's length transaction and you're purchasing the property for value. So if someone has listed their property for sale, you are purchasing the property, then you are having a title search. We as the title company and title attorneys are reviewing that record of ownership to ensure that there aren't any properties, and whomever is transferring the property over to you is warranting the title. They are saying there are no issues. If there are issues that come up, then we will defend you in any kind of action. That's also why you would get title insurance, because us as the title company, we're saying that we have searched title and we believe, based on a review of records, that title is free and clear and you are taking fee simple ownership. So those are the two differences. One is very risk heavy for the person receiving the property. The other, that being the quitclaim deed, and the other being one that is much more beneficial to the buyer. And there's a lot more coverage in that situation.
I see. Yeah. And that's super helpful to know the difference. And then also for you to define some of those terms, because, title insurance, I've bought several houses and I didn't ever really know what that was. So it's,
Right.
That's actually a valuable service I paid for. That's good to know.
It is very valuable, and it's not, a recurring cost. It's something that's a one-time fee, and it's based on the purchase price of your home.
Yeah. Well, that's good. That's good to know. So I'm not just throwing, good money after bad or anything. It's actually
Nope, I don't sell things I don't believe in, and I for sure believe in title insurance.
All right, excellent. So I want to talk too about something called probate, which comes up a lot when you're talking with lawyers. So a lot of times probate is required in order for heirs to sell a loved one's home. But can you avoid the probate process?
Yeah, there are plenty of situations that you can avoid the probate process. I mean, there are many times that you cannot avoid it. But the ways to avoid it, at least here in Mississippi, would be there are trusts that are available. So we have irrevocable trusts and revocable trusts. A lot of times I don't think that they're worth the cost of having a trust if you're just talking about your primary residence, because there are other ways to avoid probate. And here in Mississippi, with a revocable trust, you still have to go through a 90-day creditor period. So once you sell the property, the proceeds from the sale still have to be held in the title company's trust account until a 90-day creditor period passes. I think that's a misconception with revocable trust here in Mississippi. So again, a lot of times I don't believe that a trust is worth it. There are many times that a trust is great, but here in Mississippi specifically, if you just have a homestead, I don't necessarily think that a trust is what's best because of the cost involved. However, we have what's called a deed reserving life estate, which is another way around probate. What that means is essentially the person that owns the property continues to own it so long as they live. And then once they pass away, whomever they want it to go to, it goes directly to the beneficiary without the need for probate. There are cons to that. If you want to sell or mortgage the property during your lifetime as the grantor, so the person that owns the property outright, if you want to do that, then the signature of whomever you're giving the property to is required in order to do that. And this is what makes it irrevocable. So it's irrevocable without the whomever is receiving the property upon your death without their signature. So a lot of people like that option because, again, you're avoiding probate, you're avoiding creditor waiting periods. Whomever is receiving the property can sell it immediately upon your death once the death certificate has come in. But there are definitely pros and cons. The last option is a transfer on death deed, but there are definitely pros and cons with it. So it is revocable during your lifetime, meaning you can change it as many times as you want without the signature of whomever you're giving the property to. However, once you pass away, whomever is receiving the property cannot sell or mortgage the property for 3 years and 90 days after your death without going through the probate process. And the reason for that is creditors' claims still attached to the property if it's a transfer on death deed. So there's lots of different options, lots of different pros and cons. And really, it's one of those things where you come meet with us and we'll tell you what the best option for your situation is. But there are ways to avoid probate. It just is a situational thing on what's best for you.
I see. And so, yeah, it sounds like there's a lot of options to explore. And let's say for some reason that none of those options works for me and I still need to go through probate to maybe sell, my parents' home or something. What does that probate process look like?
The probate process is generally the same here in Mississippi for a testate estate, which is one where there is a will, and an intestate estate, which is one that there is no will involved. So if you go to sell the property, it's a great idea to sell it while the estate is pending. A lot of people have a misconception that the property cannot be sold until probate has closed. However, we can sell property while the estate is pending. The process would be you come meet with us, we get the relevant documents that we need from you. We do a petition to open the estate. The estate is then opened. We start the 90-day creditor period. We start the heirship period, which is a period where you tell us who the heirs of the decedent are, which would be spouse, children, siblings, parents, whatever the situation may be. We get that information. You're able to then list the property for sale, get it under contract. Once it's under contract, you send that to us as the probate attorneys, and we file a petition for authority to sell with the court. The court then approves or denies that request. Most of the time it's approved because we are selling for fair market value. If it's for fair market value, it's then approved. We can close on the transaction. We just have to hold the funds in our trust account or in the registry of the court until the full probate process is over. Typically, there's a misconception with how long probate takes. If it's an uncontested estate, everybody's on board, everybody is signing joinder saying we agree, then I would say it's generally a 6-month process, because the biggest thing we're doing is we're waiting on that 90-day creditor period. And what I mean by a 90-day creditor period is there's a timeline where creditors can come and file a claim against the estate to say, hey, this person owed me money during their lifetime, and now I am owed this money to be paid from whatever monies come into the estate. So it's really not a bad process. It's something that has to be taken care of from time to time. A lot of our estates deal with properties that realtors bring us to say, hey, this person has passed away. We need to do an estate in order for the heirs to sell it. So we do a lot of that here at Sullivan Law Firm, and then we close for Coast Title Company. We'll close those transactions. So it's an easy process either way, as long as everybody's in agreement.
Yeah, and as long as they call you
Right.
and get a good
Right.
lawyer.
Because some take longer. Some take longer.
Given everything we just talked about, and it that could feel complicated or overwhelming maybe to some people, which again reinforces the need to call you. But given all that, what should buyers and sellers be looking for when they're looking to purchase real estate? Like, what should be in the documentation before they sign?
So we talked about this in another episode, but the most important thing for a buyer and seller to look at is going to be the tenancy for the buyer. The seller is not as important to the transaction when you're talking about it from an estate planning perspective and if you're talking about what happens upon death. But when you're talking about a buyer and all the important documents that you look through, it's really important to review the deed of trust, to know what that means for you. It's where you pledge the property as collateral for the loan. Your promissory note is super important to look at. It's your promise to repay the loan. It typically has the loan amount, the interest rate, your first payment due date, and your principal and interest payments. Those are really important to look at. But again, from a buyer's perspective, one of the most important documents to look at is not a document that you're actually signing. It's a document that the seller signs, but it's the document where you take tenancy to the property as either, individually in your name, as husband and wife, as joint tenants with the right of survivorship, whether it's in your business name, whatever it may be. It's not a document that you actually sign, but it's a document that's super, super important for the purchaser to review.
Nice. Yeah, we talked about that in a previous episode. Yeah, some of these documents that maybe get glanced over in a closing, but you really should take the time to understand them and what they are and what they do.
Absolutely. And feel free to ask questions, whether it be to the closing attorney or even prior to the closing. You could ask the closer to send you a copy of the deed for you to review prior to the actual closing taking place. It's really important to review, and it's a simple thing to review, but make sure you ask questions on it. What does this mean? What does this tenancy type mean for me? It's a very easy explanation, and it's a great thing for you to ask.
And I think that's a great tip because the closing attorney, from my experience, having gone through this several times, they do this all day long, every day, and it just starts to, blend together after a while when you do that. So they're flying through this stuff because they know it front side and back side. So you need to, stop and say, okay, I don't understand this. Help me understand this.
And we don't mind. We all have our spiel. All of us closing attorneys that handle it day to day. And you're right. We have the same thing that we talk about a million times a day, 10 different ways. But if you have a question or you're a first-time home buyer and you have no idea what we're talking about when we talk about an escrow account or your deed of trust or your primary residence affidavit, whatever it may be, say, hold up, Nicole, can we talk about that a minute? What does that mean? And again, most important one that you're probably not going to go over with most closing attorneys, but I try to go over here at Ghost Title and Sullivan Law Firm is the deed. Super important.
And I do want to know, because in the last 5 years or so, I'm sure that the loan closing process has evolved, especially as now we're going to digital and remote kinds of closings. What do buyers need to know about that?
We are going towards more technology based in closings, but I mean, tech and just communication, all of those things are super important and are all evolving with time. I would say that unfortunately here in Mississippi, we still don't recognize remote online notary. So we still have to have what's called wet signatures at closing on certain documents, which are typically going to be the deed of trust that we talked about, the deed, various other documents that have to be notarized. But it's a changing world to the extent that we have e-closings so part of the package from the lender is done online, and then the wet closing documents are done here in our office, or we can just send you to a notary, whatever is most convenient. But the other thing is we as the closing attorneys are becoming fraud busters to an extent because so much fraud is occurring in our industry specifically. There's a lot of vacant lot fraud, wire fraud, all of those things. And that's something that we have to keep up to date on. And we have new software, really some cutting edge software that we have really put a lot of money and time and effort and information gathering on that we feel makes us better equipped to handle the future of the real estate industry.
Yeah, and that's great. I'm glad you're getting out ahead of those trends because that's just going to only help your clients to get, to get what they need to get.
Absolutely.
So, Nicole, it's been great talking with you today. I know I've learned a ton. I think our listeners have learned a ton. Yeah, thanks for dropping by.
Thanks for having me. It's always a
Thank you.
pleasure.
And to our listeners, thank you for tuning in to Close to Home with Nicole Sullivan. To connect with Nicole and the team, visit sullivanlawfirmplc.com. Be sure to like, subscribe, and leave a review so we can get this show out to even more people who need to know this important information. And with that, hope you have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.